If you've just been nominated to be an executor and you're not sure where to start, this is going to be a quick and dirty video just to show you the main steps of how an estate administration and probate is run in the state of New York. All right, so this is here to help you if you need to just know the overview. If you have specific questions about certain steps, let me know. But this is going to be an overview of estate administration time frame. All right, so our estate administration time frame. Step one, someone's just passed away. You've read the will and you have learned that you are the executor, or there is no will and you've learned that one of you has to step up to be the administrator. First thing you're going to need to do is gather information. Information is the hardest thing to do. This is generally the step that takes the longest. Now, we need to have enough information that we can fill out the petition and the supporting documents. This type of information you're going to be looking for. You need the original last will and testament. If you know the attorney that has it, request it from them. You need a full certified death certificate. You need an original. Get it from the funeral home. You will absolutely need the funeral bill, whether it's been paid or not. Get it from the funeral home. The next thing that you'll need is addresses of everybody on the family tree. You need contact information for them and physical addresses. That is going to be one of the biggest steps. The next thing you'll need too is if there are any predeceased relatives, we need to get proof of death for them. That can be fairly simple. It could be a death certificate, it could be an obituary or a prayer card, but you still need to find a proof of death of any predeceased relatives. Fine point, if your person that passed away was divorced, you'll also need a divorce decree showing that the prior spouse is no longer eligible to participate in the estate. So all of that together is going to be the very first thing you have to do. And quite frankly, it's one of the hardest things to do. So if you can get through this part of an estate administration, you can do the rest. All right. This is the big deal. So you're overwhelmed. It's very difficult. This is the big deal, is just getting this done. Now, if you decide you have enough assets in the estate that you want to hire an attorney will put all of these documents together for you and tell you specifically what you need. If you don't, you can go to the surrogates court and they will give you public petitions where you can hand fill out. They can't give you any advice on how to fill it out, but they can hand you the paperwork so you can say, okay, I need to know the names and addresses of all the family and the beneficiaries, but what's the difference between a beneficiary and a distributee? Court cannot tell you that. So they can give you some of the documents so you can take a look, but that's pretty much it. You also are going to have to pay a filing fee to get all of these things filed and processed in the court. Now, in New York, everything gets filed through surrogates court electronically now. It all gets uploaded. There are a few pieces in hard copy that have to be at the court, but for the most part, scans are all fine. All right, so once we have all the documents in front of the court, let's say we get into a stickiness where we have a beneficiary or a family member where we just can't find. Either they don't want to cooperate with us or we literally can't find them. They moved off the face of the planet and I have no idea where they are. If we know that that's an issue, you're going to have to request from the court a citation date. A citation date is basically an opportunity to address the court and to have every member of the family address the court and say why they have a problem with you serving as executor. You as the executor or the proposed administrator have to attend. If you do not attend, the court will dismiss your petition. You have to go, but you don't have to go in person. You can attend on your phone. You don't have to come to New York to do any of this stuff. All right. So once we get a citation date and the judge has issued it and we've had the court date and the court date has come and passed, generally at this point, we're looking about maybe 2 to 4 months into the entire process of an estate administration. The court then gets to consider either it will dismiss your petition or it will issue a decree. If it dismisses your petition, you can start over and address the issue that the judge had, or if the judge issues a decree, congratulations, you're now a formal executor and administrator. That is important to note the date that the decree is issued. When you take a look at your letter, you're going to get letters of executorship or letters of administration. There will be a date on the bottom that the judge signed it. That is the opening date. I want you to take that date and you're going to write down 7 months from that date. That's going to be your target to close. Now, once you have that page, you need to apply to the IRS for an EIN and get a bank account. The bank account is going to be your basket that you're going to put every item that you get from the estate into. If you get checking accounts, you get bank accounts, you get property sales, you did a yard sale, all the money is going to get dumped into that bank account. So, and that bank account can't be yours personally. All right. I have a lot of people that think, oh, I'll just put it in my own checking. That is a terrible idea. You have to get your own EIN in a separated account. This is a fiduciary role, meaning it's not you. You're managing someone else's stuff. So you have to do this. Otherwise, you're going to be in trouble when we get further down the line. You have to file tax returns for both the estate and the decedent. A decedent needs a final tax return for the last year that they earned income, which generally is the last year someone is alive. If the estate earns over $600 in income because the estate has rentals or the estate has anything else that's an income producing asset, the estate will also have to file tax returns. When you agree to be an executor or an administrator, you are agreeing to take care of those things for the decedent. I'm going to use the word decedent just because it's a common term for me, but most people haven't heard that. It just means dead person. So, creditor deadline. Now, once you get the date, 7 months from the date of opening is the earliest you can possibly close. I like to close as quickly as I can on an estate because that's the creditor's time frame that closes. So anybody that the decedent owed money to, think hospitals, think phone bills, think personal loans, think credit cards, they have to go to court and put in a claim against the decedent's estate for them to receive money from the estate before a beneficiary does. They have to formally go to court and do this. So don't pay them in advance. You know, if you just got named an executor, you don't even have letters yet, I know the credit card companies and student loans are going to call you. Don't pay them. Instead, make them file a claim once the estate is open. What you tell them now is, hey, I don't know what's going on. I'm not the executor yet. Just hang up the phone. Don't talk to creditors. Creditors have 7 months to step forward and file with the court. They're going to file a letter with the court that just says this person owed me this amount of money for this thing, right? Now, if you decide that, oh, I know he didn't have a credit card and I know that he didn't have a bill, and you decide that you're going to give money away to the beneficiaries before the 7 months has elapsed, you could run into a host of problems if a medical bill shows up on month 7. And that does happen sometimes. Generally, medical bills will show up around month 4 and 5. Sometimes they don't show up till later. So if you distributed assets and then the estate's unable to pay all of its bills, the executor can be held personally liable. All right, distributing assets. We've gotten to the end of our 7 months. We're somewhere here in our 6 months. We've gotten all of our assets gathered. They're all sitting in our bank account. We got a fat stack of cash, or we've got cash and in kind, but we know where things need to go. So right before we get to the end of the 7 months, we can start to take a look at doing an informal accounting. And informal accounting just says, this is all the money I've collected, these are all the bills I've paid, this is my plan to distribute everything. Send the informal accounting to the beneficiaries in advance and show them, this is what I got, this is what you're going to get. As long as the beneficiaries are okay with the informal accounting, you can start preparing receipts and releases for them. So pay off the creditors, get the receipts and releases from the beneficiaries, then pay the beneficiaries. When all the beneficiaries have been paid, you are going to file final estate closing paperwork. The estate closing paperwork is pretty simple. It's basically just an affidavit of fiduciary that says, I have done everything I'm supposed to do. All the money is gone where it's supposed to go. All the receipts and releases are here where it's supposed to go. This is the final value. I filed all the taxes. There are no liens, right? So it's very basic paperwork, and there's an inventory of assets in there. Once the court gets that, they can say, look, all right, that works. Everybody's in agreement. Everyone filed receipts and releases. You can have an informal closing. Now, if someone has a problem with what you've done as an executor, this is where it's going to show up. So when you're in the very beginning, you might think that the beginning of the estate is the argument. It's not. The end of the estate is actually where the arguments come in, especially if they think you've mismanaged assets or property. So you want to make sure that the informal accounting is done and done well before you do the final paperwork. But as long as you don't have any issues, you can get the final paperwork in. Now, typically, estates can take as short as 9 months. I've seen them done. Like, we're ready, we're good to go. We've got one person, it's easy. We can do short as 9 months, super easy. However, in general, resign yourself to understanding that this is going to take at least a year, maybe 2. A lot of times when someone just passes away, we feel like we have to do this and we have to get it done now, and it's very urgent. And at the end of the day, we can only do what we can do. The days are going to pass, but this process is a process and it does take a lot of time. So usually it can take about a year to 16 months. And sometimes, depending on the nature of the assets, it can take even longer. There is no time frame to close. So you can have an estate open very long. There's just a time frame for creditors to arrive. And as long as you're still open, creditors can still show up. So earliest you can close is about 7 months, which means 9 months in total. Usually it's a little bit longer. So if you are a new executor and you have questions, this is just meant to be an overall time frame so that you know what to expect at all the next steps. If you need assistance or you have any other questions, leave a comment down below. I'll do the best I can to answer it, or give us a call and we can do what we can to help you walk through this process. Have a great day.